Day for the most significant law to be passed since then, since the last 30 years.
And prohibits guns in sensitive places and requires background checks on all ammunition purchases.
Statute means what it says. It says that a convicted felon cannot possess a firearm.
I'd like to thank the leaders and members of the House and Senate for working together to get this done. I especially want to thank the families.
It doesn't say he can't sell a firearm that the government is possessing on his behalf.
Attorneys also disagreed whether high-capacity mags are considered firearms or accessories. New Oregon gun law. Oregon passed Measure 114 in November, which would ban the manufacture, purchase, or sale of mags capable of holding more than 10 rounds of ammunition. The law required permits for people purchasing firearms, requiring a background check and a firearm safety course. It also limited the capacity of mags for firearms, allowing users to keep mags that hold more than 10 rounds but limit their use unless permanently altered. The law also closed the Charleston loophole, a federal law that allows firearm transactions without a completed background check if the background check has taken more than 3 days to complete. The plaintiffs in the federal case raised 6 constitutional challenges, including the violation of the Second Amendment. The state argues that the Bruin case, which found a New York state law unconstitutional, allows for permitting regimes that are shall issue, meaning that the person administering the permitting process is required to issue permits to people who meet the qualifications. The Supreme Court in Bruin was careful to say that its test was not creating a regulatory straitjacket for states, stating that if there are unprecedented societal concerns or extreme technological changes, the kinds of regulations that will suffice to show a tradition of regulating arms in the country needs to be looked at as a question of analogies rather than an exact match. In the context of the large capacity mag restrictions, the state argues that the prevalence of mass slayings by single actors is an unprecedented societal problem, and that the court can only uphold these regulations if these things that functionally did not exist had been regulated at those times. The plaintiffs argue that lawful citizens should not be prohibited from owning high-capacity mags just because they are used in terrible ways in mass slayings. The state will present evidence next week about the frequency of firearms, particularly large-capacity mags, and their use in mass slaying events. The argument is that these mags are not well suited for defensive or lawful use, but primarily make a difference in mass slayings. The federal trial is a bench trial, and the judge will rule on the arguments presented by the plaintiffs and the state court. The state trial in the fall will likely be similar, with expert testimony from both sides, local law enforcement and state police testimony, and plaintiffs' interest and intentions. The regulatory apparatus from the Oregon State Police and local law enforcement levels will be assessed, and the state is prepared to implement their parts of Measure 114. Measure 114 gets federal court test. The state of a court trial to decide whether Oregon's Measure 114, restricting access to firearms, passes constitutional muster. Measure 114 mandates a permit for gun purchases, the completion of a criminal background check prior to any gun sales or transfers, and a restriction on the sale, transfer, and manufacturing of mags that hold more than 10 rounds. The focus of the 5-day trial will be on whether the Second Amendment upholds the gun control laws in question. The case involves the right to bear arms under the Second Amendment, the right to be free from the taking of property without just compensation, and the right to understand the law, according to attorney Daniel Nichols, who is representing the Oregon Firearms Federation, Oregon State Shooting Association, the National Shooting Sports Foundation, several rural sheriffs, and others. The bill and the state refer to what Nichols and other witnesses for the gun rights groups called standard capacity mags that are currently in wide use as large capacity mags.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
They emphasize that since 1990, more than 100 million people have legally purchased mags that hold more than 10 rounds for self-defense. Lawyers for the state disagreed, arguing that mags aren't actually regarded as weapons, but rather firearms accessories, and that it's highly uncommon for a self-defense situation to necessitate firing more than 10 rounds. Instead, large-capacity mags are frequently used in mass slayings and can be restricted due to the additional harm they inflict, according to the witnesses they intend to call. One of the named plaintiffs, Brad Lowry, the sheriff of Sherman County, stated that after he retires, he still wants to be able to use large-capacity mags to defend his family. Additionally, he favors giving Sherman County's 1,900 residents, who are protected by him and 6 other deputies, the freedom to purchase whatever firearm they want. Customers who are interested in self-defense, according to Jessica Harris, operating manager of the G4 Archery Outdoor Store in North Plains, buy things with as many rounds as possible. If Measure 114 becomes law, her store would be obliged to sell its current mags out of state in order to liquidate them, which would result in a sharp decline in earnings. The following are the queries addressed to U.S. District Judge Karen J. Immergut, who refused to block the new Oregon restrictions in December before a state judge suspended them in a different case. Questions on Oregon's Permit to Purchase program. Is Oregon's Permit to Purchase program considered a shall-issue licensing practice consistent with the history of firearms regulation, or does it violate due process rights by preventing people from exercising a basic constitutional right? This question is based on a decision made by the U.S. Supreme Court in a New York case last summer. A regulation that imposed tight restrictions on carrying firearms outside the home was overturned by the New York Supreme Court. The decision instructed lower courts to assess challenges to gun control laws using a new text and history criteria. Courts must assess whether the plaintiff's desired action is protected by the Second Amendment in its plain form, and if it is, whether the regulation is in line with the nation's long history of gun control. According to Douglas N. Letter, Chief Legal Officer for Brady United, during a televised news conference last week, the decision has left a wide range of questions regarding gun-related prohibitions unresolved. Mark Hanisch, a professional shooter who has served as a sales executive for multiple gun companies and is currently vice president of sales for the Arizona-based Timney Triggers mag manufacturer, said that mags holding more than 10 rounds are common in his deposition on behalf of the plaintiffs. Hanisch confessed owning shares worth over $1 million in Ammo Inc. and has more than 18 years of experience working for businesses that market large-capacity mags. Senior Assistant Attorney General Brian S. Marshall showed Hanisch images of 14 stacked Surefire mags, either 60 or 100 rounders, that were found in the hotel room of the slayer in the October 1, 2017 Las Vegas massacre, the country's deadliest mass slaying. He testified that he was in favor of the sale of 100-round mags to civilians. Scott Farron, an attorney for the Gun Safety Alliance, accessed the Surefire website, which features advertisements for high-capacity mags as well as other firearm accessories. Hanisch argued that it is fair for Surefire to offer high-capacity mags to civilians, since it gives them the upper hand in self-defense. The $12,000 raised from the sale will be utilized for self-hurt prevention, according to Ashley Lebinsky, a former curator in charge of the Cody Firearms Museum and senior fellow for the new Firearms Research Center at the University of Wyoming College of Law. She also admitted to consulting work in 2017 for Daniel Defense, the producer of the AR-15 rifle used in the Uvalde, Texas elementary school shooting in May 2022 that resulted in the slaying of 19 pupils, 2 teachers, and 17 other people. Challenge to Oregon's new gun laws. The conclusion of the case brought by firearms advocacy organizations challenging the validity of gun legislation adopted by voters in Portland federal court. A number of elected sheriffs, proprietors of gun shops in Oregon, and other proponents of firearms filed lawsuits last year alleging that Measure 114 is unconstitutional. During opening statements, Daniel Nichols, a counsel for the plaintiffs, stated, "This case is about constitutional rights." He stated that it concerned the right to keep and bear arms under the Second Amendment as well as the right to keep property. Beginning, the state's defense of the new laws is anticipated to go on for several days. For her decision on whether or not Measure 114 is constitutional, U.S. District Court Judge Karen Immergut ordered the parties to respond to more than 24 legal questions. 2 of those questions will be particularly important. One wonders if mags qualify as bearable arms. Another query concerns whether widespread shootings are an unprecedented societal concern. It might be more difficult to restrict mags if they are determined to be weapons rather than accessories. Additionally, tougher control of firearms under the Second Amendment may be appropriate if it turns out that mass slayings represent a considerably new public safety risk. Both inquiries are meant to address the new criteria put forth by the U.S. Supreme Court in its decision in New York State Rifle and Pistol Association v. Bruin last year. The Second Amendment, which protects the right to bear guns, was curtailed by the court's conservative majority decision, and a new standard for its application was established. One of the first pieces of legislation to be examined against the new guidelines established by that ruling is Oregon's new gun regulations.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
I'm sure it's enormously high.
It's 36 per 100,000 people.
I just felt that I needed to be able to protect myself.
Measure 114's stronger gun control regulations were approved by Oregon voters in November, with 50.6% of the vote. The law prohibits the production and sale of mags that hold more than 10 rounds, and it mandates that anybody wishing to purchase a handgun first get a permit. To obtain a permit, you must pass a safety training and a federal background check. Measure 114 is being defended by the Oregon Department of Justice and the Oregon Alliance for Gun Safety. No matter how the case turns out, the law won't take effect right away. In Harney County, where the statute has been contested under the state constitution, it is being obstructed by a preliminary injunction issued by a state court. September is the anticipated start date for the state lawsuit. An adverse decision in the federal case this week is anticipated to be appealed by both parties. Nevertheless, the trial's evidentiary record will be taken into account by any subsequent appeal judges as well as by the justices of the U.S. Supreme Court, should the matter ultimately be heard by that court. Trial to test an open argument. The firearm advocate's case was shortened due to the court's decision to limit the scope of the week-long trial. The gun groups had hoped to present evidence showing how Measure 114's permitting process would violate the constitutional rights of those wishing to purchase firearms. However, Immergut set those arguments aside, stating that evidence about the law's potential future application may cause harm are unripe. The order states that plaintiffs are welcome to bring a case about how the law infringes on their constitutional rights if it goes into effect and they can present evidence of harm. The trial is focused on whether the state can regulate mag capacity to 10 rounds or fewer. The plaintiffs, Adam Johnson, Jessica Harris, and Sherman County Sheriff Brad Lowry, have testified about their experiences with firearms and their family's history in law enforcement. Johnson testified about an incident in Indiana where he was shot at twice and returned fire with 13 rounds. Harris testified that if she was limited to selling firearms with smaller mags, she would have inventory that she would no longer be able to sell, and her business would be harmed. Lowry also testified about the popularity of the AR-15 style rifle among the county's residents, stating that ranchers use it for predator control, specifically to protect cattle from coyotes, which require significantly more than 10 rounds. Effective large-capacity mags. Mark Hanisch, a veteran of the firearms industry and current vice president of sales for Timney Triggers, an Arizona-based manufacturer of replacement triggers for rifles and handguns, was one of the many experts that the plaintiffs called. He has also worked in sales for FN America, a division of Fabrique Nationale, a Belgian firm that manufactures firearms for the American public and military, as well as a competitive shooter who has won contests. The plaintiffs paid Hanisch to give a speech on semi-auto rifles and detachable mags with more than 10 rounds of ammunition. Hanisch claims in his affidavit that almost all of the handgun and rifle lines offered at FN America during the time he worked there were sold with large-capacity mags.
Today, we say more than enough. We say more than enough.
No Democrat has ever tried to get anybody's guns. I mean, that's just a lie that they tell, and y'all ought to stop perpetuating their lie.
We can reach compromise on guns We ought to be able to reach compromise on other critical issues from veterans' health care.
To have their firearms, which are being held by the government, transferred to a third party for the third party to sell.
Atlanta, Buffalo, Uvalde. And for the shootings that happen every day in the street that are mass shootings we don't even hear about.
During cross-examination, Brian Marshall, Senior Assistant Attorney General for the Oregon Department of Justice, questioned Mark Hanisch about his previous role as Vice President for Marketing and Sales at Surefire, a company known for producing mags capable of holding up to 100 rounds. According to Hanisch's LinkedIn page, he worked at Surefire from 2016 to 2018. Marshall asked Hanisch if he was familiar with the term the Las Vegas shooting, referring to the tragic incident that occurred on October 1, 2017, where a lone gunman fired upon a music festival crowd from a suite on the 32nd floor of the Mandalay Bay Resort. The shooting resulted in the slaying of 60 people and numerous injuries. Marshall presented Hanisch with images of large-capacity mags found in the slayer's hotel room and inquired whether they resembled Surefire mags. Hanisch responded that he couldn't determine the exact capacity of the mags from the pictures, and there was no clear indication that they were actually used. Marshall then displayed a series of photos depicting AR-15 style rifles and long mags discovered in the shooter's room, to which Hanisch agreed that they appeared to be Surefire 100-round mags. Marshall subsequently posed the question, "Do you believe it is likely that Surefire 100-round mags were used in the deadliest shooting in U.S. history?" Hanisch replied, "From those pictures, yes." Federal judge upholds Oregon's gun rules. Oregon's new gun safety rules, which voters approved last fall, have been deemed constitutional by U.S. District Court Judge Karen Immergut. The order found that banning large-capacity mags and requiring a permit to purchase a firearm are in keeping with the nation's history and tradition of regulating uniquely dangerous features of weapons and firearms to protect public safety. The order comes after a week-long trial in early June testing the constitutionality of Oregon's new gun laws, which voters approved last fall. The Supreme Court's conservative majority decided that no one should need special permission to exercise their Second Amendment right to carry firearms outside their home. Large-capacity mags are not commonly used for self-defense and are therefore not protected by the Second Amendment. The Second Amendment also allows governments to ensure that only law-abiding, responsible citizens keep and bear arms. Ballot Measure 114 passed in November with 50.6% of the vote, and since its passage, firearms groups, sheriffs, and gun store owners filed lawsuits challenging the law. In January, a state court judge blocked the law from going into effect. The law would ban future purchases of so-called large-capacity mags that can carry more than 10 rounds of ammunition and require those wishing to buy a firearm to get a permit first. Permits will require applicants to complete a safety class and a federal background check. The federal trial focused almost exclusively on the mag restriction portion of the law. Plaintiffs argued regulating mag capacity infringed on the rights granted by the Second Amendment. Attorneys pointed to the Supreme Court's 6-3 ruling in New York State Rifle and Pistol Association v. Bruin, which states lower courts can no longer consider whether a law restricting firearms serves public interests, such as enhancing public safety. The Supreme Court's Bruin ruling also states firearms regulations must be consistent with this nation's historical tradition of firearm regulation. Lawsuits against Oregon's Measure 114. Numerous lawsuits have been filed against the state of Oregon in response to Measure 114. One of these cases is the Arnold B. Brown lawsuit, brought by the governors of America and Goa, which was filed in state court. Additionally, several federal court cases were initiated and they were eventually consolidated under one judge. The lead case within this consolidated group is currently pending. Measure 114 goes beyond establishing a permit to purchase requirement. It also imposes a ban on the future sale, purchase, and transfer of firearms that the state considers to be large capacity. While owning a firearm without a permit is not illegal under the measure, obtaining a permit is necessary for purchasing any new firearm. Due to implementation challenges, numerous lawsuits were filed against the state of Oregon to prevent Measure 114 from taking effect. These legal actions include the Arnold B. Brown state lawsuit and multiple related federal cases, which will be the focus of our discussion here. Initially, a federal court judge in Oregon issued a temporary halt on the implementation of the permitting scheme for a period of 30 days. However, The mag ban was allowed to go into effect immediately. Concurrently, in the Arnold State lawsuit, Judge Robert Rocio of the Harney County Circuit Court granted an outright temporary restraining order. This TRO effectively halted both the permitting scheme and the mag ban from being implemented.
We are not finished. We are not finished. We are not finished.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Not one more! Not one more! Not one more!
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
Subsequently, a hearing on the motion for a preliminary injunction was held in the state court. During this hearing, Judge Rocio upheld his order to temporarily restrain the permanent scheme. He further stated that his order would remain in effect until the state of Oregon provided notice that they could successfully implement their new permitting scheme. Additionally, Judge Rocio issued an order granting a preliminary injunction against the mag ban in the state. While these actions were taking place in the state court, there were still pending federal lawsuits awaiting resolution. These federal cases continue to loom over the implementation of the firearm regulations in Oregon, upholding Oregon's firearm laws in federal court. Following an expedited hearing, the federal case judge was upheld both the permitting scheme and the mag prohibition in Oregon. In her conclusion, the judge highlighted two key questions before the court. After a week-long bench trial, she determined that the answers to both questions were affirmative. 1. Can the state of Oregon impose a limit of 10 bullets for law-abiding citizens before requiring reloading? 2. Can the state of Oregon require firearm purchasers to obtain a permit that includes a background check, safety training, and consideration of mental health status? The judge argued that mags exceeding 10 rounds are not suitable for self-defense and do not receive the same level of protection. She supports the restriction on mags on this basis. While other uses of firearms may be lawful, the Supreme Court's case law explicitly recognizes self-defense as the core of the Second Amendment right. Hunting and recreational gun use, while not explicitly protected in the Constitution, are not directly prohibited either. Acknowledging that there may be legal reasons beyond self-defense for firearm usage, the court emphasizes the validity of the state's regulations. Narrowing Second Amendment interpretation. The court in the case has taken the step of reducing the scope of the Second Amendment, arguing that it protects an individual's right to own a commonly used firearm primarily for the purpose of self-defense. This step has been made by the judge. This decision is considered as a continuation of efforts by lower courts to improperly apply and restrict decisions made by the Supreme Court. In addition, the judge intends to put restrictions on how the expression common use for lawful purposes might be interpreted, which was used in the Heller and Bruin instances. She contends that it ought to mean that the firearm in question is regularly used for the purpose of self-defense, as opposed to being used occasionally for that purpose. This is analogous to the efforts taken by lower courts in the wake of the Heller decision, in which certain circuit courts moved to restrict the reach of the verdict. Despite the fact that the judge is unhappy with this view, it is consistent both with the wording of the Second Amendment and the precedent that has been set by the Supreme Court. On the other hand, she does not concur with this interpretation. If the subjective intent of the user alone were sufficient to demonstrate that a firearm or attachment is predominantly used for authorized reasons, notably for self-defense, then the vast majority of firearms and accessories in the country would pass that standard. Instead, the judge argues that the appropriate criteria to apply is common ownership, which can be seen as an example of the approach used by the Supreme Court in the Cayetano case. In that particular case, the Supreme Court came to the conclusion that the widespread ownership of 30,000 stun guns across the country established their protection under the Second Amendment due to the common legal usage of these weapons. Criticisms and potential outcome. It would be overwhelming to describe all of the problems that exist with the judge's opinion in this matter, yet these problems exist. The decision is inconsistent with itself, lacking coherence and consistency, and it departs from previously established standards while also misrepresenting the facts. In the Heller case, for instance, the judge erroneously applies the Bruin precedent and fails to uphold the language, history, and tradition of the Second Amendment. This can be seen in the context of the case. One component that raises some concerns is the judge's interpretation of the Cayetano case. In it, she incorrectly argues that the test involves actual self-defense usage of 30,000 stun guns, which raises some concerns. This misunderstanding completely changes both the judge's intentions and her conclusions about the case. However, there is some positive news in the Arnold State Court case, where the preliminary injunction against the mag ban was granted by Judge Ratio. This offers hope in challenging the Oregon regulations. Regarding the Oregon case, a summary judgment hearing recently took place, with a full trial scheduled for early September. It is anticipated that Judge Ratio may grant the summary judgment in favor of the plaintiffs, given his previous inclination. As the TRO remains in effect, this decision is not expected to have an immediate adverse impact on the state of Oregon. That's all for this video, folks. See you next time.